Late DA Richard Brown's legacy of one of a hard-charging, tough-on-crime prosecutor. Queens is the most punitive borough. The district attorney's office sends more offenders to jail on misdemeanor cases than any other New York City DA. Would you continue that stance or change it? And if so, how?
Now, we obviously have to reform. That tough-on-crime approach was as a result of the crack epidemic that came into Queens in the mid-'80s. And Judge Brown took over in '91. I think there were about 2,000 homicides in the city. And that rate has gone down where there's now about 50, 55 in Queens.
So you're saying that's outdated?
I'm saying there's no need for that approach anymore. I think we got to now concentrate. And he did go for diversion programs when he took over.
So how will you change it?
Pardon me?
How are you going to change it?
I'm going to change it by concentrating on bringing low-level nonviolent offenses to divert them into programs and decline to prosecute certain, like one bag of marijuana cases, things like that. That's how I'm going to change it.
What other cases would you decline to prosecute?
Right now, I can only think of that. It would be a case-by-case basis.
What's your position on prosecuting so-called broken windows offenses, public urination, turnstile jumping, for instance?
Turnstile jumping is a problem. You don't want to saddle anyone with a criminal record for jumping a turnstile, but the other side of that equation is that you got John Q. Citizen paying his or her toll with a Metro card, and these other people who are taking advantage of the system and just going through the gate. You can't have that in society. So I would make it a summonsable offense, and this way we wouldn't put them through the system. It would be a summonsable offense.
And do you think that that would appease those fair-paying public who feel that they're paying and others aren't?
I would hope so.
Okay, question number 3. The use of recreational marijuana is still against the law in New York. Are there any marijuana prosecutions that you would undertake?
Well, sale of large amount of marijuana I would undertake. The sale of a large quantity of marijuana.
That's it?
In terms of what, yeah.
Well, I mean, what about the sale near a school, a sale to minors?
Oh, definitely near a school to minors. The only thing I would not prosecute would be a minor amount of marijuana possession. Otherwise, I'd prosecute the rest of them and hopefully divert those people to programs as well.
So you don't think, having small amounts of marijuana is a crime?
Not one little bag of marijuana.
So the new bail statute does not allow someone to be held pre-trial for misdemeanor assault, even though this is frequently the initial charge in a domestic violence case. Did you support this change in the law, and how will it affect domestic violence prosecutions going forward?
I don't support that. I supported no bail for a minor nonviolent offense. Assault should be, prosecuted. There should be bail on it if the case calls for it. I started the Domestic Violence Bureau in Queens, and that was part of the Special Victims Bureau, but it became prevalent, the violence between people with those relationships. So it's a very tough area, and we have to, be careful on those cases. We have to
But so now that it's the law, how would you try to deal with it if you became DA?
You try to convince them to change the law.
Who's the they in that statement?
The legislators.
You think you would be effective?
Yes.
I mean, there seems to be a new wave in this country of going more progressive, more liberal, more defendants' rights. How would you convince the legislature? What argument would you make?
Well, I was at a number of crime scenes, murder scenes, where an order of protection was pulled out of the pocket of the victim with blood on it. And some of those were minor assault cases in the past. The violence escalates often when people have a relationship. What starts as a minor assault or a harassment sometimes wound up as murder. That's why when I put a new assistant DA in the Domestic Violence Bureau, I always told them to make sure you handle the case as it was a homicide, because it may turn into a homicide.
So how would it affect, if this law is still in effect, how would it affect the domestic violence prosecutions if you were the district attorney?
Well, we'd have to be very vigilant in making sure that the victim was protected. We would have a, if there was any necessary, well, if we thought there was a possibility of harm coming to the victim from that defendant who's out without any bail on him or her, we would have, a phone provided for the victim. We'd have the tour put a conditions car, go by that house every hour or whatever we felt was necessary. We would take precautions because our main thrust is to protect the victims of these crimes, and especially domestic violence. We have to be very vigilant because it's an ongoing relationship, an ongoing problem that often escalates.
The next question is this: should sex workers be prosecuted?
Sex workers, to me, should be provided services that they need to try to get them out of that life, because they are, in my opinion, they're victims of that whole industry as well. It's the human traffickers that we want to prosecute. It's the human traffickers that we should be focusing our prosecutorial efforts on, as well as the Johns, because if you didn't have the customer, you wouldn't have the industry. But sex workers, to me, we should try to provide them the services they need and help them get out of that life.
Since Richard Brown was such a tough prosecutor, should there be a review of all the sentences?
Richard Brown, I didn't see him as an excessive prosecutor. I did not see that. The sentences handed out were by the judge.
Okay.
It was under the judge's purview. The defendants have their right to appeal, and I'm sure if there was an excessive sentence, they've appealed it.
So, but do you think there should be an overall review of the sentences that were handed out over the last several years? As, I think the Queens DA prosecuted and looked for a high level of crimes. So do you think there should be a review of sentences, and if so, should you recommend, under what circumstances would you recommend a reduction?
If there was a hardship case, I would not recommend an overall review.
What would hardship be?
If there was a specific case that merited mercy, that merited a reduction in the sentence. But that would be, the vehicle to that would be an application before a judge.
But wouldn't the DA have to make a recommendation?
Yes, the DA would.
And doesn't the DA in Queens, isn't there a sentence review board in the district attorney's office, or could there be?
There could be.
Would you have one?
I don't see a need for it.
Okay.
A DA has to do the right thing, and if a DA does his or her job properly, all of that is included in the right thing. Doing the right thing encompasses all of these reforms. The law evolves, and the job evolves, and society evolves, and we have evolved over the years.
So you're telling your prosecutors, do the right thing and we won't have to do any reviews?
No, I'm just telling you, when a DA does his or her job, following the mantra of doing the right thing, usually it all falls into place.
But would that be the mantra you gave your prosecutors if you were the DA?
Do the right thing. Yeah. And if there was a need for a review, then we would, adopt it.
So, next question. Discovery laws were recently changed. What's your position on the requirement that witnesses to crimes have their identities provided to defendants before trial? What steps would you take to protect witnesses from pretrial intimidation?
Well, we've had a lot of problems with that over the years, and the biggest problem culminated with the murder of a grand jury witness, Mildred Green, in 1987, back when the crack gangs were running South Queens. She was murdered after she testified in a grand jury, because she testified in a grand jury. Every case has to be evaluated not only by the assistant DA, but by his or her bureau chief to make sure there's no risk to the victim or the witness by disclosing the location of the victim or the witness. And we have to be very vigilant about that.
So would you set an office policy that would say that even though you have to disclose the identities, you wouldn't disclose where they live or any other identifying?
I would set an office policy that if there's any possible harm to come to a witness or a victim. If there's a thought of that and it's based on evidence or facts, then we would apply to a judge for a protective order. So we wouldn't have to disclose the names or addresses or contact information of a victim or a witness. Yes, that would be an office policy. If we don't protect our victims and witnesses, it's going to preclude us from prosecuting cases because it's going to put a chilling effect on other possible witnesses to a crime, a real chilling effect.
So it sounds like you're anxious to challenge the new discovery laws.
I'm anxious to protect the victims and the witnesses of any cases in Queens County.
Would you actively investigate charges of tenant harassment?
Of tenant harassment? If they're violation of the penal law, if they're starting to, violate the penal law, and criminal mischief charge or possible attempted assault charge, whatever the facts lie, I would.
How would you handle requests from ICE?
Well, I would make sure that they stay away from the courtroom, stay away from the proceeding, because over the years we've been very vigilant that no one interferes with the administration of a Queens case. When I was on the bench, I would make sure that if someone in that courtroom was going to be rearrested, that the detectives did it outside. They don't come into the courtroom, they go outside or outside the courthouse.
Why
I
not?
would treat that the same way.
Why wouldn't you let him in the courtroom?
Because I didn't want any problems in the courtroom. Someone's going to get arrested in a courtroom. You never know how the reaction could be. You have to wait. You have to coordinate with the court officers, and then everyone goes outside because there are civilians in that courtroom. You don't want anyone getting hurt.
Should Rikers Island be closed?
Rikers Island is a violent place. It's an antiquated place. Yes, it should be closed, but it should be rebuilt on Rikers Island. Right now, there are 2 facilities on Rikers Island that are vacant. Together, they held 3,200 prisoners in the past. If they can refurbish those on Rikers Island to make state-of-the-art prisons that would be safe for the inmates as well as the correction officers, they could do that. If they can't refurbish those to meet the requirements of the new, safer prisons, which are horizontal, not vertical like the ones they're proposing in the neighborhood, then they can knock them down and start rebuilding a new facility there. Or I believe there's some vacant land on Rikers Island. They should start building there tomorrow if there's a vacant spot on Rikers Island. They could put shovels in the ground tomorrow. The plan they have right now is kicking this can down the road 9 or 10 years, and it's costing, estimated, about $33 billion, I'm told. That's insane. They could refurbish every tenant, every apartment in the New York City Housing Authority for that kind of money.
So in other words, you'd like to avoid having a new prison built on the streets of Queens?
There should be no prisons in Queens, Brooklyn, Bronx. Nobody wants, or Manhattan, nobody wants a prison in their neighborhood. The reason that people want the prison and the people who are advocating for prisons in the neighborhood, so the families of the inmates can have better contact, more frequent contact, and they still be part of the family, which is good. However, in reality, I think it's more than 65%, I think, is the cutoff. I think 65% of the inmates live in Queens that have Queens cases. 35% do not have Queens cases. So right away, that, waters down the argument to put a prison in a neighborhood. Second of all, the latest plan they have, and they've had a number of plans, the latest plan, all the females are going to be the Women's House of Detention, which is now on Rikers Island. They're going to put it in Queens. So the Bronx, Brooklyn, and Manhattan are not going to have facilities for female inmates. That's discriminatory. They're going to have it only in Queens. So a woman can have a case in Brooklyn, and she could reside in the Bronx, That doesn't matter. Her case, she's going to be housed in Queens.
So you're saying that Queens is getting a double burden because you'd have a woman's house of detention and a man's house of detention.
I'm not saying it's getting a double burden. I'm saying it's not, you know, the reason that they want the prisons in the neighborhoods is so the families can be there. But the women, their families are all over the city too. But they are going to have their relative female who has got a case pending housed in Queens.
So
That's
what
what I'm
about the
saying.
men being housed in Queens? The plan to have a men's jail in Queens.
I don't want any jail in Queens. It should be on Rikers Island.
Should the women's house of detention be on Rikers Island also?
I don't see why not.
I think
Where else are you going to put it? Because I don't believe in putting these prisons in the neighborhoods.
because
Because number one, the facility that they want to put in Queens is about 27 stories high. That dwarfs everything around it. There's a 6-story house of detention right now. It's been in there since 1960, I believe. That's only 6 stories. This is going to be 4 times the height of that thing. It's going to be the biggest building in the neighborhood. It doesn't fit, number one. They want to knock down the present house of detention. There was a parking lot, which was a multi-tiered municipal lot right next to it. It took them 5 years because they found that the engineers found that parking lot was structurally unsound. It took them 5 years to pancake that down to one level. They just finished that about a year ago. It took them 5 years to do that. They want to go over that now, the parking lot, that 5-year plan that, you know, they want to put the house of detention there, close off 82nd Avenue. It's going to be a very huge building. It's going to be where the house of detention is now. It's going to be where that parking lot was. And it's going to cause them to close the two-way street, the 82nd Avenue that divides the courthouse from Borough Hall.
So you say tall is bad?
The modern prison theorists say the best prison should be built horizontally for aesthetics, for safety. A lot of it has to do with safety. If you have a prison that's 27 stories tall, you need what? Elevators. And you've been in courthouses a lot. I know that, Marsh. I used to see it. Half of those elevators have a problem every day. Sometimes there's only one working elevator. It's dangerous for correction officers and prisoners to depend on these elevators all day long. If they're breaking down, it could be dangerous. There's no need for it. Plus, it's better for the prisoners to have a horizontal prison. Aesthetically, it's a better atmosphere.